The upcoming changes to unfair dismissal legislation will result in an increase in tribunal claims. For employers, now is the time to prepare for those changes. Hi, I'm Isobel Barton, a solicitor in the employment team at Myerson Solicitors. I've discussed the key upcoming changes to unfair dismissal legislation in another video, including the reduction of the qualifying period from 2 years to 6 months, the extension of the tribunal limitation period, and the removal of the statutory cap on compensation. In this video, I will focus on what employers can do now to reduce the risk of increased claims and to prepare for these changes in practice. There are 3 key areas: recruitment, contractual terms, and early performance management. Firstly, employers should review and strengthen recruitment processes. With employees gaining unfair dismissal protection much earlier, employers will have a shorter period in which to assess whether a new recruit is suitable for the role. This means it will be more important than ever to make well-informed recruitment decisions from the outset. Employers should also ensure that appropriate vetting and verification checks are carried out before employment begins. This should include checking qualifications, references, and past experience, as well as right-to-work documentation and, where relevant, regulatory or background checks. Employers may also wish to consider whether health checks are appropriate for particular roles. However, care should be taken to ensure that any health-related questions or assessments are lawful, proportionate, and relevant to the role. Employers should also be mindful of their obligations under the Equality Act, including the duty to make reasonable adjustments for disabled candidates and employees. Managers involved in recruitment should receive training. Recruitment decisions should be objective, consistent, and properly documented. Managers should understand how best to assess candidate suitability for the role, considering carefully how closely each candidate matches the job specification and person specification for the role. Of course, they should also avoid discriminatory decision-making and keep appropriate records of the reasons for selection decisions. This is particularly important because even with the qualifying period changing to 6 months, employees can still make discrimination and whistleblowing claims from the start of their employment. Second, as stated in my previous video, employers should review contractual terms and update the length of their probationary periods if they are currently too long for the new 6-month service eligibility. The contract should also make clear what notice period applies during probation and after probation has been passed, and include an express payment in lieu of notice clause. Employers should carefully consider whether they have sufficient flexibility to terminate employment where there are early performance, conduct, or suitability concerns. Thirdly, performance management is more important than ever. Employers should ensure it is rigorous, timely, and properly documented. Some employers may wish to hold more formal, regular review meetings rather than waiting until the probationary review meeting. These meetings should not be treated as a tick box exercise. They should be used to assess whether the employee is meeting the required standards and whether there are any concerns that need to be addressed. At the outset of employment, employers should set clear objectives and expectations. Employees should also understand what is required of them, how their performance will be assessed, and what standards of conduct and attendance are expected. Where concerns arise, they should be addressed promptly. The employee should be told what the issue is, what improvement is required, the time frame for improvement, and the potential consequence if improvement is not achieved. Managers should also keep written records of performance, discussions, probations, review meetings, objectives, feedbacks, and any warnings given. This evidence may be critical if dismissal is later challenged. Once an employee has 6 months service, employers will need to ensure that any dismissal is supported by fair reason, a reasonable investigation, and a fair procedure. Where the issue relates to performance, this will usually involve giving the employee a reasonable opportunity to improve before any decision to dismiss is made. Employers should also ensure that managers understand issues and when they need to be escalated to HR or senior management. Early escalation can help avoid procedural errors and ensure that concerns are dealt with consistently. Ultimately, the best defence against increased employment tribunal claims is a proactive approach. Strong recruitment practices, effective contracts, and timely performance management can significantly reduce legal risk and place businesses in a much stronger position if disputes arise. At Myerson Solicitors, our experienced employment law teams can support employers with contentious employment matters, including unfair dismissal, constructive dismissal, discrimination, and whistleblowing claims. We protect your interests while focusing on speed, efficiency, and reputational risk. To discuss how these unfair dismissal legislative changes may affect your business, call us on 0161 941 4000 or visit our website at www.myerson.co.uk to find out more about our employment law services.